Every criminal case is going to have a consideration about bond. What that means is when a person is arrested, they usually get booked into the jail, and there's a question of whether or not they should just be released straight from the jail, or if they have to put up money or property as an assurance that they're going to follow the rules and come back. The word for that is a bond or a bail. Those terms can often be used interchangeably. What it really means is someone gets arrested, they'll put up a certain amount of money to the jail as a guarantee that they will return and show up for all of their court dates. Most people might be familiar with the idea of a bail or a bond just from hearing about the U.S. Constitution. The 8th Amendment of the Bill of Rights to the U.S. Constitution specifically provides a right against having excessive bail. It's part of the provision against cruel and unusual punishments. Florida Constitution actually takes it a step further and declares that people have a right to a reasonable bond. So that really means that, again, in every case, there has to be an analysis done by the court of whether or not there's going to be a bond issued. Many charges might have a bond amount predetermined, where the county or the circuit will have a court order establishing what they call a bond schedule that kind of sets out the basic amounts for certain charges, where they say, for example, a third-degree felony that's nonviolent will have a $5,000 bond. And so that might be the starting point. There's always going to have to be the question of whether or not a person gets a bond and how much. People who don't necessarily get a bond right away when they're arrested, they will usually have the opportunity to be advised about a bond by their first appearance. And we talked about this in another video. The first appearance is generally the hearing within 24 hours of a person being arrested. Judge decides whether or not there's probable cause to hold the person, and if there is, they issue a bond amount. So that's what we're talking about today. The bond amount can get determined by the judge at the first appearance. So there might be some people that are being held on a very, very high bond or no bond at all based on them being arrested, but the judge at first appearance can elect to give them a bond. Sometimes the judge does that on their own. Sometimes the accused has their attorney present at the first appearance to make that argument. But no matter what, if for whatever reason a bond isn't addressed at the first appearance, there's still always an opportunity to have bond hearings in the future. And there are a lot of different reasons for a bond hearing. Florida law provides that people have a right to a reasonable bond in most circumstances. There are some exceptions. One exception is if a person is charged with a crime that's punishable by life or the death penalty, they may not necessarily be entitled to a bond. Oftentimes, if there's a particular charge where it is of such a serious nature that a person may not necessarily be entitled to a bond, the court conducts something called an Arthur hearing, where the state tries to prove, based on its evidence at an early stage, that proof is evident and the presumption of guilt is great. That's a fancy lawyer way of saying that there's a lot of evidence that shows the person is guilty. So cases where there might be a confession or video evidence of the crime, or perhaps there is DNA evidence or fingerprint evidence to link someone, it's essentially a showing that it is basically beyond a reasonable doubt. That's a determination made by a judge. If they don't meet that criteria, then the judge is absolutely permitted to issue a bond, and they usually will. But there are a lot of factors that go into deciding whether or not a court is going to grant a bond and how much. They look at the type of charges that a person is facing. They look at the criminal history of a person, whether or not that person has ever failed to appear, and whether or not there's any other reason to believe they might be a flight risk. The court's also going to look at the resources and the finances of the person accused. What's reasonable for one person may not be reasonable for another. And so generally, a bond that a person can't afford is oftentimes considered to be unreasonable because it's inherently unreasonable that they can't afford to pay it. There are a lot of factors that the court will take into account in deciding whether or not to grant someone a bond. Going back to the exceptions, I'll add another exception is whether or not there are no conditions that the judge can order that would essentially keep the community safe and protect them from the acts of the accused defendant. Now that's kind of putting the cart before the horse when we talk about innocent until proven guilty. But for the purpose of a bond hearing, that is something the court absolutely does. If the judge believes that a person is charged with a crime and that nothing is going to actually keep the community safe, then even though it's not punishable by life in prison, the court may decide to not give that person a bond. Now, that's not going to be for any kind of crime. That's usually going to be seen on more serious crimes. Crimes involving violence, whether they be domestic violence, robbery, attempted murder or murder, sex crimes like sexual battery. These are the types of crimes that often will be of such a serious nature that the court is going to be more concerned about whether there's any risk or danger to the community. On the other hand, someone who's charged with, say, possession of cocaine, possession of marijuana, probably isn't going to have the same concerns or implications that someone who's charged with a violent crime has. Now, when we're talking about that people in Florida do have a right in general against an unreasonable bond, I want to point out that only applies to new cases. There are other types of cases where a person may not be entitled to a bond. One such example is a violation of probation. Let's say a person is charged with a crime and they work out a deal with the government and they get put on probation. Now they've been sentenced and they get put on probation. If they violate it, they are charged with what's called a violation of probation. That brings the case back to square one, where they're facing the maximum punishment minus any time they've already served. Because on a violation of probation case, the person has already been sentenced to the underlying offense, there is not going to be the same consideration in giving them a bond, and that person does not have a right against an unreasonable bond. Now, the court might still decide to give someone a bond, but that would be within the discretion of the court, meaning it's pretty much just a decision up to the judge, and it's not something that can really be subject to review. Another example of a type of case where a person might not be entitled to a bond is if they're already out on release and they violated the terms of pretrial release. So with any case, if a person is bonded out of jail and they're at their own liberty, there are certain conditions that they have to follow. The most basic and obvious condition is to avoid getting arrested on any new charges. But the court is allowed to order other conditions that are reasonable as part of someone's release. The court can order that a person, in addition to not getting any new charges, they could issue a curfew. They might order that the person isn't to take any drugs or alcohol and be subject to random urinalysis or drug tests. There might be an order that they aren't allowed to have contact with someone, whether it's the victim or a co-defendant. And so if a person violates the condition of their release, whether it's any of those specific conditions or they get a new charge, they can get hauled back into jail in front of the judge, and the judge will revoke their bond. Because they were already given a bond and they violated it, they've forfeited their right to a bond, and the judge doesn't have to give them another bond. Now again, the judge might discretionarily, I don't even know if that's a word, the judge might in their discretion give someone a bond and let them be free. If a lawyer can do that, more power to them. But again, there's no right to a bond if someone's already violated a condition of release or in a violation of probation. Now, once you've had this analysis and you've had a hearing, the judge may either deny the motion and say, I'm not going to do anything, or they could grant the motion and say either I'm giving you a bond or I'm lowering the bond to a different amount that you can afford. And from there, if there's a bond, a person can bond out by either putting up the money, regardless of how much that is, that they pay to the jail to secure their release. If it's a $500 bond, maybe it's some small misdemeanor charge, they could just pay that $500 and they'll be released. If it's higher, they're gonna have to pay that higher amount, whether it's $5,000, $50,000, or $500,000. Now, in general, if a person is going to pay their own money for a bond, most of the time they'll get that back. As long as they don't violate any conditions of release, as long as they show up for court on time, they will be issued a refund of the money that they put up for bond, minus any court costs. So if a person pays a bond and they get the money back, then any court costs that there might be from taking a plea or going to trial and being sentenced will be deducted. On the other hand, if the case is dismissed completely, then in all likelihood, the court will be issuing a full refund. Now, most people don't necessarily have all of that money at their disposal to pay a bond, especially because no one is ever planning on getting arrested. So most people don't have money kept aside for a bond just in case. When there's a situation where a person has a bond, but they may not be able to afford the entire bond out of pocket, they can hire a bail bondsman. The bail bondsman will pay the bond on behalf of the defendant in exchange for receiving usually 10% of the bond as a payment to them plus collateral. So again, as an example, let's say someone is charged with a crime and they're facing a third-degree felony. And so the bond is set at $5,000. It's not the most amount of money in the world, but it's also not chump change. And so a person may not be able to pay the $5,000 to be released. A bail bondsman would be willing to pay that $5,000 on the behalf of the defendant, and they'll put the money up. But the defendant will have to pay 10% or $500 to the bail bondsman. Now, the difference with putting up the money on your own is that when the case is over, that person's not going to get their money back. It's the bail bondsman that gets their money back. But any money that was paid to the bail bondsman is going to stick with them. That's how the bail bondsman gets paid. Having the bond issued and being able to get a bail bondsman is a great way of being able to secure release, especially if finances are tight. Now, it's also important to remember that there are so many different conditions that can apply for a bond. It's going to depend on the kind of case. So just one of the examples I would give is there's something called a Nebula Hold. A Nebula Hold is when a person is charged with a crime that usually involves some kind of illegal or criminal enterprise. So if a person is charged with drug trafficking, human trafficking, something where there is an ongoing criminal enterprise or business that's being accused, the court can say, we don't care if you have the money for a bond. You're not allowed to bond out until you show us where the money came from. It's the court's way of making sure that money that's going towards a bond isn't being paid with ill-gotten gain. In other words, the court doesn't want someone who is selling drugs or is prostituting people to use the money from that to pay for their bond to get them out of jail. So instead, at a bond hearing, when there's a Nebula Hold, we're going to have to show the court not only what the person who's paying that bond, what they do for a living, showing their pay stubs where they got the money that's going to be paying for the bond, but their relationship to the accused, right? Why is this person putting up their money? In most cases, you're going to have a family member that might be doing that. A family member can come to court and say, I have a real legitimate job. This is what I do for a living. Here are my pay stubs. This is my son or my cousin, and I'm going to be paying the bond for him. And so once the court is satisfied that they know where that money is coming from and that it is not money that came from, the legal phrase would be ill-gotten gains, basically some kind of criminal business or enterprise, then the court will release the Nebula Hold and allow the bond to be posted. That's another thing to keep in mind. Right? There are so many different considerations to keep in mind when we're talking about a bond hearing. Right? You want to be able to secure your release to be able to get out. So it's important to be able to have an attorney who's going to know the issues, who's going to be familiar enough with the case to argue what a reasonable bond is for an individual. And if for whatever reason a person has a bond and they still can't afford it, then the attorney should go back to the court and advise them that this bond can't be afforded, right? And that's part of the argument, that a bond that is out of reach for someone they can't afford isn't reasonable. And it's that reasonable question that is paramount in Florida in determining what bond is provided. There might be, like I said before, pretrial release conditions that they apply, whether it's no contact with someone, not being able to return to a location, not having any drugs in their system. Maybe the court will order that the person has to wear a GPS monitor. But in any event, the bond hearing is an essential component of a criminal case in order to help a person be released from jail prior to trial or any plea deal, prior to any potential conviction that may occur. aside from the benefit of a person wanting to be free and to sleep in their own home and to be in their own house, there's also the fact that it's a lot harder for someone to assist their attorney in their case if they're stuck in jail. It's a lot harder for a person to be able to find witnesses, provide phone records, or access to their own email, any kind of evidence that they think might be helpful for a case if they're stuck in jail. So it's so important to not only be able to access your attorney, but to do it meaningfully. And a bond hearing is a critical way of getting people released from custody so that they can meaningfully contribute to their case. The only other thing I would really want to add is that a bond hearing is something that should generally happen early on in a case. There's no reason to necessarily let someone languish in jail unless there's a good reason for it. Maybe they have another case, maybe their bond was revoked. But for the most part, it's prudent to try to address the bond issues early in the case before the evidence starts piling up, before there are other setbacks that might occur in the case. But at the same time, there's still always the opportunity to go back to court later on, right? Judges aren't going to entertain you coming to court every day doing a bond hearing, but you can do a bond hearing early on in the case. And if for some reason there's something that's changed or you can't afford the bond, then your attorney can file that motion to come back to court. So there are multiple times where you can address it, and courts will generally take them pretty seriously. Right? Getting someone released from custody is an important part of any criminal case. People are innocent until proven guilty, and for all of its flaws, the bond system is how we do that in Florida criminal cases, of getting people released even though they've got pending cases, sometimes very serious cases. But in general, people have that right to a reasonable bond, and we always fight for that for all of our clients, to get them out and to get them home. So a few things will happen. If you pay a bond and you skip town and fail to appear for court, first thing that the court's going to do is forfeit your bond, right? That's not your money anymore. That's theirs. The second thing they'll do is they'll issue a warrant for your arrest. In Florida, they generally call it a capias, which is a type of bench warrant. It's literally just the judge at their bench saying, well, this person failed to appear. I'm going to issue a warrant for their arrest, issue a capias. And that's an arrest warrant. Right then and there, the judge might set a bond and say, this is going to be a no bond capias, or they'll say capias, new bond at $10,000. That's, again, still going to be within the discretion, the decision of the judge. But if 20 years go by, or if any amount of time goes by, and that person is arrested and brought before the court, certainly one can ask for another bond, but the odds are going to be probably against it. A lot's going to come down to, why did they fail to appear? Where were they for the past 20 years, right? Why is this person why should this person be given a bond? So if a person has failed to appear on a case, that's already told the judge that they may be a flight risk, that they may not necessarily be trusted. So while I've certainly seen it, I've had cases and I've had clients where they failed to appear, the judge revoked their bond and issued a warrant, no bond, where we were able to go back and get the judge to either issue a new bond or kind of go back on all of it. But for the most part, if a person skips town, they lose that bond, they lose their money, and once they get arrested, they're going to sit in jail until the case resolves. We can talk about, and we probably will talk about in another video, what happens if 20 years go by. But until that case actually resolves, whether it goes to trial, there's a deal, or they drop it, that person might have to sit in jail until everything resolves. That's it for today's video. I really enjoyed discussing this subject with you. Make sure you grab your gavel and smash that like button. Be sure to share this widely on social media, Twitter, Facebook, anywhere else you want. Subscribe to our channel. And of course, be the jury. I want to know your verdict about what you thought about this video in the comments section. So either leave me your verdict, or if you have any questions and you want to ask something for the lawyer, please do so in the comment section. And you never know, your question might be featured in a future video.